Mr. Leibowitz, I'd like to start with you. When we look at the Internet, we're examining something that didn't exist at the founding, but it's important to evaluate what kind of thing it is so that we understand our own regulatory power relative to that thing. You can analogize it to a channel or instrumentality of interstate commerce. Even though the Internet didn't exist 250 years ago, channels and instrumentalities of interstate commerce certainly did. In light of the fact that it's a channel or instrumentality under this theory, how would you describe the scope of Congress's authority over the Internet? Would you describe it as exclusive?
I wouldn't, well, I would describe, I guess, the better architecture, and this goes back to the Commerce Clause, it goes back to Gibbons v. Ogden. I would describe the better architecture as a strong federal law, or strong federal laws. We're talking about privacy, but there can be others, that sets a single high standard for consumer protection. And of course, it is integrally involved in interstate commerce.
And state governments, of course, have a legitimate interest in regulating a number of things that might incidentally touch the Internet. So how do we, as a Congress, balance the need to operate on this interstate channel or instrumentality of interstate commerce while not trampling over their authority? Well,
that's a fair point. And you know, we all believe in states as laboratories of democracy, but we don't have state-by-state seatbelt laws. We don't have state-by-state FAA laws. California, when it passed its own state law, which proved that lawmakers can protect consumer privacy, preempted all of the municipal laws that existed. And so this would be one place, I think, where you want to craft a very strong consumer privacy law that empowers consumers and gives them more control over their data. But I think you want it to be a single federal standard enforced by state attorneys general, like your Sean Reyes, so that they can bring cases as well.
Oh, thank you. That's helpful. There's been a lot of discussion about the FTC's rulemaking authority. It's authority under the APA to make rules carrying the force of generally applicable federal law. Now, when Congress delegates broad regulatory powers to an agency, subsequent rulemaking can create some unintended consequences, because what's in effect happening is that agency is making a law. And sometimes it can become difficult to reverse the burdensome impact that might have on a particular industry. Mr. Leibowitz, I'm concerned about overly prescriptive privacy regulations and the impact that they have the potential to have, particularly in the area of competition. You think that laws and regulations and even some rulemakings by the FTC could have a potential GDPR-like impact on competition by insulating big market incumbents against competition, imposing additional barriers on entry?
Well, I think you always worry about any rules or any laws that create new barriers to entry. We've seen that with GDPR. I would say that this committee, and we'll see where your legislation comes out, could give any rulemaking authority to the FTC under some guardrails. For example, in COPPA, where you gave some delegation, but a limited delegation to the FTC, they weren't allowed to increase the age from 12 to 14 of COPPA, but they were allowed to determine what constitutes sensitive information. So in 2012, when we updated COPPA, because COPPA was passed, and Senator Markey was one of the authors, was passed at a time when we didn't really know what the internet would do. We made precise geolocation a sensitive category of information. But you could also come up with a lot of the sensitive categories of information yourself if you wanted to do that.
Right. In some ways, an agency like the FTC could be said perhaps to be operating at its best when it's playing the role of cop rather than lawmaker. Enforcement actions rather than new rulemaking endeavors can be helpful, and they also help increase rather than diminish certainty within the industry. Would you agree with that?
And then you, of course, have oversight with your antitrust subcommittee over the FTC and have so for some time, and so you know the agency well. We think of the agency, or people at the agency think of it as first an enforcement agency, second a policy agency, and maybe third a rulemaking agency when Congress clearly delegates that authority for rulemaking. That's why Congress put the FTC under the Magnuson-Moss Act, which makes it very hard to do general rulemaking without a APA delegation from Congress.
Thank you very much, Mr. Leibowitz. Thank you, Mr. Chairman.